All rise. The Court of Appeal in before the 5th District of the State of Florida is now in session. The Honorable John M. Harris, Judge presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session here at the 5th District Court of Appeal. As Marshall indicated, I'm Judge Harris. I'm joined on the panel this morning by Judge Wallace and Judge Pratt. One case on our docket today, it's case 24-1214, Bloomberg versus Security First. If you have any electronic devices, noise-making devices, please go ahead and shut those off at this time or silence them so we're not interrupted. Keep in mind the proceedings are being recorded and broadcast on YouTube. Each side's going to get 20 minutes. Appellant, you can reserve as much of that as you would like for rebuttal. Typically, we'll set it at 5 minutes. If you want anything other than that, please just let me know. And if you are ready, you may proceed.
Thank you, Judge. 5 minutes is fine. Thank you.
Thank you.
Good morning. May it please the court. My name is Chad Barr, and I have the privilege of representing the appellant in this case, Denise Bloomberg. We're here today asking the court to reverse the trial court's order denying a motion for attorney's fees because the insurance policy in this case was governed by the version of section 627.0152 and 627.428 that existed when the policy was issued, and that version allowed for attorney's fees. The issue in this case is unquestionably begins and ends with Menendez versus Progressive Insurance. The answer brief, however, asks this court to disregard over 100 years of case law by Frankensteining an argument together based on cases that have no bearing on the issue that is before this court.
Counsel, you mentioned beginning and ending with Menendez. I think it was after the initial brief was filed, but before the reply brief, our court issued a decision called Smith against Universal Property and Casualty Insurance Company. I believe that was a November 8th, 2024 decision. Are you familiar with that case?
Yes.
Okay. Was there a notice of supplemental authority on the docket or of that case? Could you, I'll tell you what, if you're familiar with the case, could you address that one before we get into Menendez?
I can address it. Do you have a specific point of that you want me to address with respect to the argument?
Yes, its potential applicability to the appeal. Do you have a perspective as to whether Smith is instructive here, and if so, how?
I think Smith is absolutely instructive. What this court did in Smith was it adopted the 6 DCA's decision in the Hughes case. And the most important factor is the court applied the Menendez analysis. And so when we're looking at these issues, we're looking at whether or not, what is the statute when the policy is issued, and whether a subsequent statute affects the rights that are in the policy. And I think the simplest way that Hughes and Smith apply is by virtue of the fact that it applied the Menendez analysis. The answer brief gives us a bunch of cases that have nothing to do with contract rights, have nothing to do with insurance policies. They all have to do with purely statutory rights. This, we're dealing with an insurance policy. The Supreme Court is very clear. There's really 4 takeaways. First of all, they argue that Menendez doesn't apply because we have to look.
Just so I'm clear, the policy is silent on attorney fees, right? So the attorney fees is statutory, but it's presumed to be part of every contract. Is that what?
It's presumed to be. I wouldn't say that it's silent. It's silent in the sense of the term, the black and white words are not there. But every court in this state has been very clear that it is incorporated into the insurance policy. And every court that has addressed the issue of attorney's fees has found that with respect to 627.428, it is a substantive right set forth in an insurance policy. So there's no question about that. So we're dealing with contractual rights. There's really 4 takeaways for why Menendez applies that we find in Menendez. First, Menendez tells us why we have to do a retroactive application analysis. The issue in Menendez was whether 627.736 subsection 11 could be retroactively applied to the insurance policy issued prior to its enactment. That's straight from Menendez. That's what the issue was. All we have to do in this case is substitute out the statute. The issue in this case is, does the 2022 and 2023 amendments to 627.70152 and 627.428 apply retroactively to an insurance policy issued before those amendments were enacted? This is different than what the answer brief argues. They're arguing that we have to look at the statute at the time that the rights vest. That qualifier is missing from the Menendez case. Instead, the only qualifier is, are we applying a statute to a policy that already existed, and are we affecting substantive rights? The second thing that we take away from Menendez is that Menendez tells us that the relevant date is not the date of the accident, not the date that the claim arises, not the date the lawsuit is filed. Instead, the only relevant date is the date that the insurance policy was issued. This is an express pre-rejection of the answer brief's argument in this case that the law that applies is the law when the rights vest. The third thing we take away from Menendez is that it tells us that the law that controls is the law that is in effect when the policy is issued. Importantly, Menendez cites the two cases, one a prior Supreme Court case, the second a case from the second DCA, the first one being the Lumberman's case. And in that case, the Florida Supreme Court said a liability policy is governed by the law in effect at the time the policy is issued, not the law in effect when the claim arises. The second DCA case that the Supreme Court cites to is Hausler versus State Farm, and that case states that the date of the accident is also not relevant. It's the date that the insurance policy was issued. The fourth takeaway is that the Menendez case tells us that the right to attorney's fees is a substantive right, and any statute that seeks to limit attorney's fees cannot be applied retroactively. And I think it's important that we look at exactly what the court said in that case, and the court said the 2001 statutory amendment cannot be applied retroactively because it allows an insurer to avoid an award of attorney's fees, which constitutes a substantive change to the statute in effect at the time the insured's insurance policy was issued. Now, I also think it's important that we understand the facts of Menendez. In Menendez, the 2001 amendment that was at issue in that case was enacted 4 days after the accident in that case. And so we have an accident. 4 days later, the legislature amends 627736 and adds a pre-suit notice requirement. At the time the statute was amended, there was no claim, the claim had not vested, and there was no right to file a breach of contract action. And certainly, there was no right to attorney's fees. But the court, that was one of the three things that the court found important, was that it impaired the right to attorney's fees. So why would Menendez be talking about the right to attorney's fees if the right to attorney's fees wasn't vested, and that was the important qualification? It wasn't. The court was strictly looking at what was the date that the policy was issued, what was the law on the date the policy was issued, and was there a substantive law that sought to substantively change those rights in the policy. The cases that the answer brief cite couldn't be farther away from what we have in this case. You have the two Crimes Compensation Act cases in Williams and Bravada, and those were purely statutory rights to attorney's fees, and the court said the statute was repealed before you had a judgment, so you don't get attorney's fees. That's not a contractual case. The contractual cases are analyzed different. That's why the answer brief doesn't include any cases that deal with contracts or contractual rights, because it's a different analysis. The only case that comes close that the answer brief argues is Ram of South Florida versus WCI. And that was the case where there was a cure statute. The contract was illegal because the contractor was unlicensed. There was a cure statute. The contractor who was unlicensed couldn't sue on the contract because the contract was illegal because he was unlicensed. When he was attempting to get, or before he had attempted to get licensed, the legislature repealed that cure statute. And the second DCA concluded that the repeal was not a retroactive application because the cure statute was a matter of what it referred to as legislative grace. In other words, it wasn't a contracted for right. It wasn't a part of the contract. It wasn't a part of the bargain that the parties entered into when they went into the contract. Interestingly, the court in Ram of South Florida, they say, quote, when contract rights are involved, the invalidation of a retroactive application of civil litigation may be based on the conclusion that the legislation impairs the obligation of contracts. The right in that case, the right to cure, was not a prescribed right in the Ram of South Florida contract, but the right to fees is a prescribed right pursuant to Menendez in this insurance policy. I think it's important to note that the the Ram Court went on to cite, they cited two very old Supreme Court decisions that did concern contracts and statutory amendments that affected the rights of those contracts, and where the amendments were enacted before the cause of action accrued in those cases. And this is the case that the appellee relied on. That case cites, the first one is Dewberry versus Auto Owners. In that case, the Florida Supreme Court explained that subsequent legislation which diminishes the value of a contract is repugnant to our Constitution. In that case, the subsequent legislation prohibited the stacking of UN benefits, but when the policy was issued, stacking was permitted. Importantly, the accident in that case happened well after the legislative amendment. The Florida Supreme Court rejected the insurer's attempt to retroactively apply the statutory amendment to a pre-existing policy, even when the amendment was acted before the loss occurred. This confirms what Menendez said before Menendez said it. When dealing with an insurance policy, the important date is the date the insurance policy is issued, and the law in effect when the policy is issued is the law that controls. The Ram Court also cited to another interesting case from the Supreme Court. It's a 1975 case, Yamaha Parts Distributors versus Ehrman. In that case, Yamaha entered into a franchise agreement that required 30 days notice to cancel the franchise agreement. During the contract period, the legislature enacted a statute that said you have to give 90 days notice before you rescind a franchise agreement. 4 years later, Yamaha sought to rescind the franchise agreement. 3 years after the enactment. The Florida Supreme Court held that the amendment did not apply retroactively to the 1970 franchise agreement, and the court explained, and this is a lengthy quote, but I trust it'll be instructive. If the trial court's order were to be sustained, the 30-day notice provision would be extended by at least 60 days through application of a law which became effective after the bargain was struck. We find no support in the law of this state to warrant this result. It's worth noting that 10 years after Rama, South Florida was decided, the fourth DCA decided Universal Property and Casualty versus Grove Isle at Vero Beach Condo Association. That case went through a very detailed analysis telling us why Rama, South Florida doesn't apply. First, the fourth DCA explained that the Ram case involved an illegal contract and a cure statute, which wasn't at issue in that case. Second, the fourth DCA explained that when an insurance policy is at issue, enforceable, this is important, enforceable, and this is a quote, enforceable contract rights were created when the policy was issued. Third, that Grove Isle case followed Menendez and reminded us that an insurance policy is governed by the law at the time the policy is issued. And importantly, the statute in Grove Isle, which altered the insurer's rights to subrogation, was amended before the loss occurred and before the insurer attempted to invoke its subrogation rights. There's other cases, but I want to get to one that I think is important for the court to really hone in on is the FIGA versus Devon Neighborhood Association case. And in that case, the insurance policy was issued in 2004. When the policy was issued, a statute existed that allowed the insurer to demand appraisal without condition. In July of 2005, the legislature amended the appraisal statute and now required an insurance company provide a notice of availability of mediation form before it could demand appraisal. That was in July of 2005. In October of 2005, 3 months later, the property was damaged by Hurricane Wilma, and a sworn proof of loss was not submitted until February of 2006, 7 months after the amendment. Now, under the appellee's theory, which law should the Supreme Court have applied in Devon? Under their theory, the Florida Supreme Court should have applied the amended statute, which stated that the insurer could not demand appraisal until the notice of availability of mediation was provided by FIGA, because that was the law when the loss happened and when the insured's rights vested. But that's not what the Supreme Court did. Instead, the Supreme Court held that the fourth DCA erred when it didn't apply Menendez, and that the law that existed when the policy was issued was the law that applied. The Supreme Court in Devon rejected the precise argument that the appellee is making here today when it said, quote, Devon contends that the two-pronged test set forth in Oldport, Chase Federal, and Menendez is not applicable in this case, and that it was proper for the district court to look only at the question of whether retroactive application would be constitutional under the balancing test set forth in that's a difficult case to say, Pomponio. We reject the argument that Pomponio dispenses with the first prong of the test for retroactivity. Our controlling precedent has required and still requires that the court first determine if there is legislative intent for retroactive application of the statute. So since at least 1975, the Florida Supreme Court has taken the position that if a statutory enactment is applied to an existing contract, regardless of whether the rights are vested when the enactment goes into effect, it is a retroactive application issue.
Can we talk briefly just about types of insurance contracts? So Menendez, as I recall, dealt with PIP insurance, right? What's your best case applying the Menendez analysis to the, private, property insurance context?
Smith and Hughes.
Okay. So is there a reason then why Smith was not discussed in the briefing, at least the reply brief, if that's your best case?
I don't have an answer to that. It could have been an oversight, or it could have just been that I don't know. I don't have an answer to that question.
Okay, but your position, though, is that Smith, at least from this court, would be your best case?
Certainly Hughes and Smith, yes, are the best cases. And the reality is, PIP is highly legislated, and now property insurance is highly legislated, and it wasn't for many years. There were various statutes that talked about property insurance, but now it's highly regulated. Just look at 627.7052 and 627.70132.
And I see that we're into your 5-minute rebuttal time, unless you wanted to reserve less.
Yeah, in conclusion of this part of my argument, I want to make sure the court is very clear that there's a very good reason that the appellee not just needs, but wants this court to find that this is not a retroactive application case, because it can't satisfy the first prong of Menendez. There's no clear legislative intent in the amendment, the 2022 amendment or the 2023 amendment, that evinces a clear intent the legislator intended these amendments to apply retroactively. So we would ask the court to reverse and remand with instructions to enter an order granting the motion for attorney's fees. Thank you.
All right, thank you, counsel. You got just over 4 minutes.
May it please the court. I'm Joe Jaco with the Gunster Law Firm representing Security First Insurance. The elimination of attorney's fees under the statute isn't retroactive in this case. There's nothing in the policy on attorney's fees. There's no contractual right at issue. The Florida Supreme Court's decision in Petty v. FIGA resolves this case. Petty explicitly clarified Palma on attorney's fees owed with the breach of a policy versus fees otherwise based on an express contractual right. And I'll say Appellant's argument is troubling. It would neuter the legislature due to the timing of private contracts. But here, the legislature eliminated statutory attorney fees prior to any action under the policy. On that basis, this court should affirm.
And Mr. Jaco, I guess I'll ask you the same question I asked your friend on the other side. Are you aware of our Smith case following the Hughes case?
Yes, Your Honor.
Okay, so could you address then your view about its bearing or lack of bearing on our appeal?
Yes, Your Honor. It does not bear on this appeal for 2 reasons. The first reason is this is not a retroactivity case. So Smith, Hughes, Buies, and the second DCA don't affect this case. You can decide this case just on the error in Appellant's incorporation theory. On that error alone, you can affirm. Second, in Smith, Universal conceded the policy issuance analysis. So on page 1 of Universal's answer brief in that case, they say there is, quote, no impediment to the statute's application to policies issued before the effective date. Security First does not concede that. Universal conceded that in Smith. They conceded that in Hughes. They conceded that in Buies. And those concessions are in the court's opinions in the 6th DCA and 2nd DCA. But again, here, Security First does not concede this. This is all on page 19 of our answer brief.
If I'm remembering right, I think maybe it's that same page, you do argue in your answer brief the Kenton's case and the Cole case, which were the two cases we specifically rejected in Smith. Yet you don't mention Smith.
Your Honor, so to explain that, so Smith says there's a policy, I should say, Smith recognizes Universal conceded the policy issue analysis. In Cole says two things. One, they first evaluate whether it's procedural or substantive, and they differ from other courts in saying it's procedural. And then, in the last paragraph of Cole, they address the inapplicability of Menendez in the case. So Cole secondarily says it's not a policy issuance analysis. But to my first point, which is that what this case is all about is appellant's incorporation theory. That was addressed in Petty. I mean, the Florida Supreme Court has on-point binding precedent. And let me say two things about that. First, Petty affirmed the second DCA's decision that first focused on an interpretation of FIGA's Chapter 631. Then Petty went on, and it unanimously disapproved of the third DCA's Soto decision, which held that PALMA fees are a claim, quote, for contractual obligations. Indeed, in the Petty decision on pages 316 to 317, the court says the insured argues that PALMA incorporated statutory fees as, quote, a part of every insurance policy, and then the Florida Supreme Court rejected that understanding. So, again, Petty, quote, says 627.428 imposes an obligation to pay fees on an insurer who has wrongly contested insurance claim. It does not alter the coverage provisions of the insurance contract itself. So Petty confirms that there's no PALMA theory to incorporate the statute into the contract itself as some express provision. Instead, the issue in PALMA was, when do fees vest? The argument was brought before the court to say they vest at judgment, and the court said no, they vest at an earlier time.
Is vesting relevant anymore after, intervening precedent Menendez? I mean, is that still a relevant consideration?
It is, Your Honor. So the vesting is the question of whether rights are substantive or not. So if you have a procedural right, courts have said there's no harm in retroactivity. If you have a substantive vested right, then the courts have said there is a harm in retroactivity. So what PALMA did is it was assessing at what point do those attorney's fees vest. Do they vest at judgment, or do they vest in the course of the litigation? PALMA never said that they vest back at policy issuance. That wasn't an issue at all in PALMA. The phrase in PALMA that fees are a part of statutory fees are a part of the policy is that they track with the policy proceeds. So as in Petty, where they say it was wrongfully contested, it's at that point where there's a breach, where there's a lawsuit, that then the fees vest along with the policy proceeds. That's the purpose of the phrase part of the policy. And this is borne out in other cases. PALMA relied on Cincinnati, which is a fourth DCA decision, and there the court says, quote, upon the suit being filed, the relief was sought to both the policy proceeds and attorney's fees. So that's the purpose of the statement, part of the policy. Nowhere, there's no Florida case law that holds that attorney's fees are an actual provision in the contract for some purpose that appellant has to create an impairment of contract through some type of retroactivity analysis. And I'll just say, appellant concedes this. So on page 29 of his initial brief, Appellant cites this court's decision in L. Ross, saying that 627.428 attorney fees, quote, vest when the cause of action accrues, right? Not at policy issuance, but at some point in the litigation. Also, appellant concedes the same on page 25 of his initial brief, citing the Florida Supreme Court's decision in Young v. Alton House that found that statutory fees vest at the cause of action.
Counsel, I have a question, and I guess it's an overreaching policy question, but in this case, the focus of this litigation is on the policy or the contract, correct?
Correct.
If we take your argument in this case and apply it forward, aren't we essentially allowing you or parties coming behind you to even provide, to the extent a line item type striking of relevant portions of a contract based upon prospective legislation that may come out? I mean, it seems like it's a piecemeal effort at making the contract, which is the subject of the litigation, irrelevant. Would you agree with that?
Your Honor, here's what I would say, is that if there's a right in the contract, right, an express right, clearly that vests at the time. If it's a statutory right, then you have to look at what the statutory right does. Is it some pre-suit notice? Is it an attorney fee? And then the evaluation that we've seen in all the cases, Menendez, the U.S. Supreme Court's Landgraf decision, is what is the relevant event, or what is the relevant conduct that vests that particular statute? Here, the courts have unanimously agreed that those fees vest at either breach of a contract, filing of a lawsuit, but no court has said that it vests at policy issuance. So to your question, Your Honor, this is all about the legislature's power. They can enact a statute that is effective immediately. If there's a vested right prior to that effective date, then the statute doesn't apply to the vested right. But if there's no vested right, then the legislation applies immediately. And here, the insured didn't have a cause of action until after the effective date, didn't have a lawsuit until after the effective date, so the attorney's fees didn't vest till afterwards. And it makes sense, because attorney fees wouldn't even be incurred until there was some type of denial of the policy. That clearly happened after the effective date. The effective date was December 16th, and the appellant didn't even file her claim until January 13th. You couldn't even have a denial before that. So all of this is happening after the effective date of the statute. I would just like to address one last thing, looking at the questions. You had asked whether the appellant's best cases were Smith and Universal, and I hope I've responded to that in the sense that, one, they don't apply because this isn't a retroactivity case, and two, Universal made the concession in all of those cases of the policy issuance. And the Hughes case, as you know, is up on appeal at the Florida Supreme Court. So I do think this court, rather than addressing or having any need to address the Menendez question, no need to revisit Smith in any way. It's all about the appellant's incorporation theory. And Petty is on point precedent for that. Let me quote.
Saying the Supreme Court's ultimate decision in the Universal case is up there now will have no bearing on should have no bearing on this case?
Well, if you were to rule in favor of appellant, it would matter, right? Because appellant has to achieve three different things. Appellant has to first find that the statute is incorporated in the policy. Then appellant has to say, now under Menendez, you have to look at the policy and see those fees. And then appellant has to say, once you look at them, you now have to find an impairment of contract, not because there's an express contractual right, but because now the legislature created its own impairment of contract by incorporating the statute judicially into that policy. That's Appellant's theory. On our view of the case, if this court decides that Petty is correct and that Petty clarified Palma and that the statute is not incorporated, that's it. That's all this court has to do to affirm. Never has to reach the Menendez question. If I may, I'd like to quote Petty once more for this clear distinction, and again, this is pages 316 to 317 of the opinion, where the court has already dispensed with the FIGA statutory interpretation under Chapter 631, and now has moved on to the Palma argument that insured makes. And on that argument, the court says there's a clear difference between an obligation to pay fees imposed by the operation of law due to upon a party due to its behavior under an insurance contract and an obligation imposed by an express provision for what the party contracted, right? So the court is distinguishing in Palma that when there is some behavior by an insurer denying a claim, right, that there's an operation of law that occurs, right? That happens, again, at the cause of action, at the lawsuit, some point in the litigation, that occurs. That is what Palma stands for, and that is different than having an express provision for which the party contracted. Two different principles of law. Palma speaks to the first, not to the second. That's the ruling in Petty. I'm happy to answer any other questions the court might have.
Okay, thank you, sir.
Thank you.
I have a lot to say, but I'll use my time as quickly as I can. When I read the answer brief, I thought Petty was probably the farthest reach that the appellee was making in this case, and after even hearing my counterpart explain it, it still doesn't make sense to me. The issue in Petty was whether FIGA had to pay a claim. The issue in Petty was the word coverage. Do they have to provide coverage? It wasn't a coverage provision. That's correct. It wasn't a coverage provision. But it doesn't say anything. It doesn't say anything in there that it's shifting what Palma said. It very clearly could have. We no longer find that 627.428 is incorporated into every insurance policy. It didn't. All FIGA has to pay is a covered claim. The attorney's fees were not a covered claim that was specifically paid for as a policy provision, but it is incorporated into every insurance policy and has been.
Counsel, how do we determine which statutes are and are not incorporated into an insurance policy in this context? I mean, is it every potentially applicable statute? Is there? I mean, what's the analysis in your view?
If it's a statute that substantively alters the arrangement between the parties, and it concerns insurance coverage, and it's incorporated into the insurance policy, there's a lot of case law on that. But here, more specifically, we have Supreme Court case law saying that it is incorporated into every insurance policy. And I think the conclusion of Petty tells you all you need to know. Because Petty's underlying insurance policy does not expressly provide coverage for a fee award, it is not a covered claim under 631.54 that FIGA must pay. Accordingly, we approved the second district's decision in Petty and disapproved the third district's decision in Soto. None of those cases discussed whether the incorporation doctrine that we're not just relying on, we're required to. This court's required to rely on it. Petty doesn't change that analysis. I want to touch real quick on, he said Smith doesn't apply because it's not a retroactive case. It's a circular argument. He doesn't explain why it's not a retroactive case. Or this is not a retroactive case. And he said it was based on a concession. I think that's disingenuous to argue to a court that it would just accept an argument just because two attorneys agreed to it. You have a duty to make sure that the law, that your decisions are correct. And Judge Harris, I can't assume I can't believe that you would issue an opinion that just because 2 attorneys agreed to it without making sure that it was the correct decision. The vesting argument still perplexes me. There's not a single case in their brief, there's not a single case that I could find that says that a right has to be vested under an insurance contract in order for Menendez to apply. There's not a single case that says that. Every case they rely on, every single one is a non-contract case. And in that case, in those instances, it makes sense. Like, there has to be a starting point. That's when the cause of action vests. Here, our starting point is when the policy was issued. The courts have been very clear about that. Menendez didn't say rights have to be vested. Hughes didn't say it. Smith didn't say it. Cole didn't say it. Cantons didn't say it. And Devin didn't say it. We have a plethora of case law that says vesting doesn't matter for purposes of determining whether Menendez applies. We have a pretty...
Do they go that far, or do they just not engage in a vesting analysis, in your view? Do they go so far as to say affirmatively vesting doesn't matter?
Well,
and that
from the
Menendez
top.
rejects the vesting framework?
I think it's important to remember that the word vesting is only used when we're talking about the second prong of Menendez. And vesting is only part of the phrase that's used. It says that we're looking at whether there are vested rights, creates new obligations, or imposes new penalties. It's not just the issue of vested rights. The courts have used that exact language to apply it to the issue of attorney's fees. So the arguments are all unsupported. We would ask that the court reverse and remand with instructions to enter an order granting the motion for fees. Thank you for allowing us to be here.
All right. Thank you, gentlemen, for a well-briefed, well-argued case. Court's in recess.
All rise.